Hello everyone and welcome to my channel Decode Bear Act. So in this video I'll going to discuss part 3rd of Indian Evidence Act, which deals with production and effect of evidence. So in this video I will going to discuss burden of proof. Burden of proof is from 101 to 114A. So before moving further about the section, one should know what is burden of proof. So burden of proof, it is nothing but it is an obligation to prove. And you know that every party, if a party asserts something in front of court, then that party has to prove that fact in front of court. Burden of proof basically is also said as onus probendi. It basically means that if no evidence is given by the party on whom the burden of proof lies, then uh, then the issue uh, passed against him. Okay, so a burden of proof basically have two distinct meaning in Indian Evidence Act. The very first thing is that uh, the very first thing is that it is a matter of law and pleading. It basically means that that the burden, whether the party come in front of court or assert something, so the burden of proof on that person, whether he is a plaintiff or a defendant. But the first who contend in the front of court, the burden of proof is on him. Second thing is burden of proof as a matter of adducing evidence. So it can be at the beginning or at a particular stage of the case. Okay, so it is unstable thing, and it shifts continuously, like we can see a type of onus probendi, right? So what does section 101 say? Section 101 say that whoever wanted desire any court to give judgment against any legal right or liability, then he has to prove this thing. For example, according to the illustration given under your Bear Act. So illustration A said that if A wanted the court to give judgment that B shall have committed the theft or a particular crime, so A who assert that B has committed a crime, so A has to prove this thing in the front of court. This is what section 101 said. Section 102 talk about on whom the burden of proof lies. It is a basically it is this section is also said to be a onus of proof, because here the burden, basically if one party prove the fact, then another party has to disprove this. So onus of probendi shift continuously unless and until the fact was not established. For example, uh, as given under illustration 1, if A sue B for the land of which B is in possession, and A contended that the land in which B has possession is belongs to him, then A has to belong to him, and C a person who basically C is a person who uh, transfer या who give that land to A by will. So A has to prove this thing, and if A not able to prove this thing, then B would retain on the position. And if A proof, then the burden of proof shifted to B, and B has to disprove this. Okay, there was a very famous case in this, is that is Subra Mukherjee versus Bharat cooking gas. In this case, the court said that where the issue, basically if the issue is, basically I want to explain by what was burden of onus of proof. So in this case, court held if there is a dispute between the party on a document, whether it is a bogus or a authentic, so the person who contended that it is authentic must prove, and and the next vice versa. Okay, so this is what now section 103. Section 103 basically talk about the burden of proof as to a particular fact. If any particular fact, the party want to prove any particular fact, then the and person who wishes the court to believe in that existence of that fact, then he has to prove that fact. For example, A, as according to the illustration, so A if prosecuted B for theft, and he wishes the court to believe that A has committed the uh, theft, uh, and further he said that the B had admitted that he has committed the theft to C, so A has to prove this admission. Okay, now section 104. 104, but before going 104, uh, we understand the importance of, and this is going to last topic for today's, we're going to discuss more about in the next video. So first, so we'll end this video on the what is the importance of burden of proof. So basically the burden of proof, uh, basically it play a very important role. And if court, or after, if a court has to decide anything, so court take decision or consideration of all material fact, and when the entire evidence which is available on the particular subject is already come before the court, then, and from whatever source it may be, so it is a well settled of question of burden of proof become immaterial. And so basically it is a determining factor of the whole cases. If uh, uh, basically it decide the case itself. Okay, and the next thing is that it basically the court find the evidence for and against so evenly balanced because of the burden of proof by proving the facts. Okay, then he decide, the court then decide accordingly. Okay, so this is what the importance of this thing is. So this is all for today. If you like my video, like, share, subscribe. Thank you so much for watching this video.